Here this evening. Thanks for your patience. Sometimes things come up in the practice of law that take a little longer than expected, i.e. telephone conferences with clients. But we are here. Thank you for sticking with us. We appreciate that. I understand how annoying that can be. So thanks for watching. We've got, take a look at this. We got Stuart, Kiki, Terry, Pixie, Tabitha, Russell from Miss, let's see, wow, lots of people coming in already. So it's been an interesting week as far as cases go that we've been following. Obviously, there's always something that is going on with the Lori Vallow and Chad Daybell matter. And literally, just as of later today, as posted today, there was an order regarding the conflict of interest motion that was at issue before the court regarding Lori Vallow and Chad Daybell. As you may recall, Lori Vallow's attorney stated on the record not once but twice, and we've played that several times, where he said that he, Mr. Means, also stated that he represented Chad Daybell. And the court has come out with an order, and it says, after a sealed hearing were held regarding a potential conflict of interest, the court listened carefully to the oral arguments and thoroughly reviewed documents submitted by the state and counsel for the defendants. After exhaustive analysis, the court finds that any conflict of interest has been adequately waived for the current proceedings. This case can proceed forward with current counsel. So, a couple of things there. Obviously, the court was originally concerned about Lori Vallow's attorney's statements on the record that he knew or actually represented Chad Daybell, because that was his argument. Hey, Judge, she is going to be staying with him. I'm his attorney as well. Not a problem. The district attorney raised the issue and determined that there was, in fact, a conflict, or believed that there was a conflict. I believed there was a conflict based upon the ABA model standards as it relates to the ethical rules of conduct. And you cannot necessarily represent a former client, particularly in a proceedings where there are conflict issues. And I'm not sure why the court would state that, and I quote, any conflict of interest has been adequately waived. Okay? What that's telling me is the court also believes and finds that there is a conflict of interest, but that conflict has been waived. All right? Interesting little set of tidbits. Why would the court, if they know that there is actually a conflict of interest, allow it to go forward? It creates nothing but issues down the road. To waive a conflict, the person that holds the attorney-client privilege conflict has to be advised by thorough independent counsel to get by the issue. Okay. I had a case once, and it was a multiple co-defendant case. Facts were terrible. They were ugly, but there was a co-defendant in the case, two brothers that wanted to be represented by one attorney. And everybody said conflict. For whatever reason, the judge allowed it. And guess what the first issue on appeal was? there was a conflict of interest, Judge. How could you have let this go forward? Now, in that particular case, there were multiple trials because the case kept hanging, and they had to be retried, and we were out of it by then. But the point is, there's a conflict. Why do that? Why create the issue? At some point, it's very likely that these two positions between Vallow and Daybell are going to become conflict with each other. It's a no-brainer. I just can't imagine why the court thinks there's no issue whatsoever other than expediency. We're going to have to start over again. Well, guess what? You're going to have to start all over again if a higher court determines that there's not going to be, that there was in fact a conflict, that it shouldn't be waivable. Most conflicts are not waivable. I'm very surprised by this. The judge that issued it in this case, the Honorable Judge Eddings, he seems to be a thoughtful, thorough guy. So maybe that's it. And obviously, we're not privy to the documents that he reviewed in this order. But he says, after exhaustive analysis, the court finds that any conflict of interest, which means there was one, has been adequately waived for the current proceedings. So let me know what you think about that, ladies and gentlemen. I'm just, little criminal defense attorney here. And, the bottom line is that it's a conflict. It's a conflict in my book. It was conflict when the district attorney saw it. The court specifically asked those questions of Lori Vallow's attorney and said, have you now or have you ever represented a co-defendant? And the attorney said no. Clearly, one of those answers was not completely truthful and candid to the court. So I simply don't understand why the court would allow it. And then the court say there is a conflict, but it's been waived. It's all good. Yeah, because everybody's friends now, so to speak. But that will come to an end. Thank you, Kaylee, for the super chat. Appreciate that. Same with Lucia. Thank you once again for the super chat. We try to read the questions. Obviously, it's a lot easier when they come in big, bold headings like that. We've never requested those, but it does make it a lot easier. So yeah, that's the breaking news there as it relates to the order of the conflict of interest. I'm just a big stickler for that. I think so. I'm just a big stickler of that. I've always lived by the rule: if you have to go and read the fine print and all the little legal analysis for what's permitted and what's not for a conflict of interest, it's a conflict. So why go there? It's just going to create issues down the road, and there's going to be issues regarding whether, who advised these people. And the judge's order here, when you take a look at this, let's just waived for the current proceedings. What is that supposed to mean? For the current proceedings? Are there more proceedings coming forward that we don't know about? Could there be a proceeding further down the road? How does it relate to the other case? As it relates that Lori Vallow has the misdemeanor charges that still remain. This is, I don't know. Hold on one second. We've gone through this. We've gone through the videos. And it's, if you go through our past videos, we've talked about the conflict of interest. And you can't represent, there's certain things where you can't have a former client where you are now adversarial to them. And that attorney-client relationship forms rather easily. And maybe they got around it by simply trying to say that, well, he may have paid and we're privy to certain things, but it really doesn't amount to a representation. And apparently then we got him, we got Chad, independent counsel so that he can talk with them, and he's aware of the conflict and he's going to waive it because they're all in love and everything's going to be great and it'll all be good. Unless and until somebody loses. I don't know. I think just based upon Mr. Means' statement to the court the last time where they were addressing the new charges in the advisement, where he stated that he simply had not represented the same people. The court knew the answer to that. The court asked the question to clarify the answer to that. And so now the court, for whatever reason, is finding that there was a conflict, but it's been waived. You can waive lots of things, but it gets into a ton of issues. For example, when someone pleads guilty, they go into court. The judge wants to make sure before they plead guilty that they understand the rights that they have, the rights that they are giving up, and that it's knowingly and voluntarily made. And it has to be based upon, here's the deal you're pleading guilty to. There's no side agreements. There's no side deals. Down the road, if somebody's unhappy with it, they're going to say, I wasn't fully advised. I have no idea. This isn't what they told me. It's just a mess. And the court, I'm telling you, in this one man's humble opinion, the court should not have allowed it and should have simply said, there's a conflict, Mr. Means, go away. I mean, think about it. The courts found there's conflict, which means that there would have been dual representation of two co-defendants that now have a conflict of interest. Lori Vallow could be sitting there and saying, wow, that guy may have a little bit more money because he, got that inheritance from his dead wife. She has nothing and he's paid for the bill. It's got to raise in the back of her mind, who is he really loyal to? Is he going to try and help him out so that he gets all his fees paid? He's got to be wondering, wow, this guy's, I thought he was my attorney and I told him a couple of things. Is he going to come back and use that against me? Right? That's a conflict of interest, ladies and gentlemen. I'm shocked and flabbergasted that the court would allow that to continue, but we shall see. I still think there's an issue, and I don't think that it can be waived. And I once knew of a case, real fact scenario. Attorney represents a guy who was an alleged drug dealer, and he was charged with various drug offenses. I seem to recall there was large quantities of drugs found in his house. Well, that individual ultimately wound up dead. And the person that was charged, may have had something to do with his source of narcotics. And the attorney represented him, that particular individual, on the murder charge. And for whatever reason, people didn't raise a conflict that he represented basically the victim and the guy being charged of murder. Went through, the guy was charged, and I assure you this was not me. And then, guess what? It's ultimately found that there is a conflict 10 years down the road when all the appeals have been exhausted, the ineffective assistance of counsel issues have been raised, and it's a conflict. And at the same time, then the attorney faces potential grievance issues through the Bar Association. And so, once again, it just really makes you wonder why the judge would allow that and set up potential issues down the road. It's just flabbergasting to me that the court would allow that to take place. Clearly, there's a conflict. So, Kaylee, agree. This seems like they must want their 5 minutes of fame. I mean, let's face it. Can anybody recall to me the last case from Idaho that received national and international attention? I can't think of one. I mean, I'm sure there has been, but I can't think of anything off the top of my head. So this is clearly the biggest case that's been around. These attorneys want to be on it. My advice would be to these attorneys, if they're not getting paid, then run. No pro bono case has ever worked out well for me in the past. They've turned out to be the biggest headache, and whatever publicity or whatever you think you're going to get from the case, it never turns out to be that way. So we will see. Let's see here. A super chat from Chicken Head. Remember that Lori's third husband, she was supposed to get his life insurance, only probably he changed it just the day before he passed away. He made his sister. Exactly. I mean, as far as we know, Lori Vallow has little to no money of her own. So, clearly everything is dependent on Daybell. And like I said, these individuals, these attorneys that are representing Lori Vallow and Chad Daybell, I'm telling you, man, not worth it. If you think that you're going to be somehow a household name and everybody in Idaho or everyone across the country is going to know you and going to hire you, doesn't work that way, okay? I remember young in my career, had a client, great client, nice client, had just gotten out of prison after multiple decades, represented a couple of little minor things. Next thing you know, I'm sitting in bed watching TV late at night, the evening news, and bam, there's my client's face all over the news, and he's charged with a horrendous crime, terrible crime. And he was like, man, Scott, I'll pay you every penny you're owned, that you're going to be owed. Just work with me. And I'm like, I'm thinking to myself, I'm a young attorney. This is going to be great. My face is going to be everywhere. There's a horrendous case. Everyone's going to know my name. Yeah, no, didn't quite work out that way. Didn't quite work out that way. We even got a decent result for the client, but nobody cared. And guess what? The person who cared the least was when it came time to get paid. Just simply not worth it. These guys, hopefully they got their money up front, because you better get enough for your time there, Mr. Means and Mr. Pryor, down the road, because I assure you, based upon what I've seen of these two individuals, of Lori Vallow and Chad Daybell, these are the clients. And there are some clients that when you walk in the door that are simply not worth it. You will tell them the retainer is $1 million because they don't have it, and that's what it would take to deal with it, because they're going to be a complete pain in the ass. They're not going to listen to you. No matter what happens, they're never going to be happy. And at the end of the day, they're going to want their money back. They're going to grieve you. They're going to make life a living hell. So hopefully these two will do that. Do you think Vallow and Daybell, these two people who have been trying to manipulate things, what's been taking place, just look at the sheer number of deceased people around, Chad's wife, Tammy, and, getting married to Lori Vallow with, 2 weeks, a week after, your wife dies. I mean, if that doesn't, make you a little suspicious and make your spidey senses tingle a little bit, that's just not right. One would possibly think that, Chad must have thought he was a lucky man in the world. Oh my gosh, I'm falling in love with this Lori Vallow, and my wife just miraculously dies from undisclosed natural causes. I mean, what are the odds? Imagine that. And, Lori Vallow needs all of her kind of ex-husbands out of the way, and miraculously something terrible happens to him. And fortunately, it was self-defense by her brother, Alex Cox. And then Alex Cox just coincidentally, who may have done some bad, terrible things, just happens to pass away just in time when the heat's kind of coming on to everybody. Wow, these guys are the luckiest people in the world. And now they've got the same attorney at one point, and it's not a big deal. The judge finds that I'm telling you, all due respect to the judge, he's the one that's got to make the decision. He's going to live with it. But, from a criminal defense attorney, someone who's practiced in this area, it's not worth it. It's going to create more headaches. All the court would have to do is say, you know what, not in my courtroom. And I have seen that. I have seen where attorneys have said, Judge, I represent both husband and wife. And the judge will say, not in my courtroom. Well, Judge, we have a waiver. We've talked. Judge will say, not in my courtroom, because they know it's going to be an appellate issue and post-conviction relief issue down the road. Hey, that's just me. What can I tell you? Let's see what some of the questions are. And, this stuff, it just came in tonight, literally just tonight. Sometimes the Idaho courts are a little late in posting those things. Otherwise, we would have obviously talked about it on the video that we put up this evening. But we just checked that. But a conflict is a conflict is a conflict. And I don't think that would be a waivable conflict at all. Let's see here. Loretta, thank you for the super chat. Isn't it a crime that Lori knew Tylee was killed by Alex and did not protect JJ? Well, Loretta, potentially, there are certain child abuse statutes in many states where if a child is put into a dangerous situation, they have what they refer to in a lot of states called reckless endangerment. If you put a child in a dangerous situation, then they will, something bad happens to them or the potential of it happening to them. You see that lots of times in domestic violence type of situations. If there's a domestic violence dispute between the couples and the children are there, a lot of jurisdictions will charge a child abuse charge as well because you are knowingly or recklessly putting a child in a dangerous situation. So yes, one could possibly, make that argument. Obviously I've said this before, a mother has one job, and that is to protect their children. A society will be judged based upon how they judge their children, the weakest among them, how they treat women in a particular society. And if there's no respect for the children, there's no respect for women, you can tell clearly that the society is on its way down. So, clearly, as a defense attorney, I can get up there and argue, Lori Vallow did everything right. She did everything. How was she supposed to know? She had no idea. But if, as a member of the community, you're sitting there, you're shocked and you're outraged by how can you not be concerned that your children aren't around? How can you run off to Hawaii and act like you're going to stay there? Well, your children are missing. It just goes counterintuitive to anyone's parental instinct that, if the reason why they weren't looking, ladies and gentlemen, was because they knew that the person that they were looking for was deceased. They're not going to go out there and waste their time. That's why they weren't out there searching. You know as well as I do, if your child was missing and they had been abducted, they'd been kidnapped, you would be doing everything possible to look for those children. You would be out there backtracking, organizing search parties, putting up flyers, doing anything you could. But it certainly wouldn't be running off to Hawaii because you thought that, what are you, OJ? You're looking for the real killer, in Florida on golf courses. You're looking for the real killer. You're looking for the kidnapped children in Hawaii. Yeah. It's ridiculous. So I don't know, ladies and gentlemen, even someday, nothing surprises me these days. And I get it. It's a smaller jurisdiction, a smaller town. Everybody kind of knows everybody. But the reality of it is there were statements made by Mark Means on 2 different occasions that had to have given great pause to the court. And I think the court order says it all in that he's reviewed the documents that were submitted by both the state, which means the district attorney, and the counsel for the defendant. And these were sealed hearings. So the only ones that are in there were the attorneys and the clients. And the court apparently went through an exhaustive analysis. I'd like to see how they got around the whole issue of representing previous clients, because I don't think you can. And then the court says, after this exhaustive analysis, finds that any conflict of interest has been adequately waived for the current proceedings. That's the court saying there's a conflict, but I'm okay with the waiver, which is somebody who's in custody, who thinks they're in love with their co-defendant, who's trying to stay together, form a common defense, and sure, I'll waive any conflict there is. Now, let's hope that the court made a thorough record and engaged in an extensive colloquy between the defendants on the record that will be there for an appeal, and that if there is an issue that's later raised, the appellate courts will be satisfied by that colloquy that was engaged with by the court and the defendants regarding the potential conflict, so that it doesn't crumble under an attack on appeal or some sort of post-conviction matter that would take place years down the road if there in fact is a conviction. A couple of comments here in our section. Silver Bubbles, you're a defense attorney and you agree there's a conflict. Yes, I do. And that's why the laymen here agree and why everybody thinks the judicial system is corrupt. And, ladies and gentlemen, there is a quote out there, and it states, and I wish I could give it the citation to the person that said it, but it says, the American judicial system is absolutely terrible, okay? But it is still better than anywhere else in the world. And as a criminal defense attorney, and some days we lose a lot, okay? We're told, nope, law's not on your side. Sorry, even though you think you're right. You have to go to trial. You have to go to do the appeals. And then ultimately on appeals, somebody tells you that you're correct, okay? It's happened in lots of cases where I've said, Judge, I'm just a little old defense attorney down here, but I've read the Constitution, I've read the state Constitution, and I've read the rules and I've read the law, and what you're doing is not correct. What the government is not doing is not correct. Denied, denied, denied. Go to trial, we lose because the evidence comes in, and then ultimately the Court of Appeal says Scott was right, okay? And so one would think that after 25 years, I could possibly lose faith in the criminal justice system. But the reality is I have not. And the reason is because I know if we're doing the correct thing, that it can make it to a higher court and it will be heard. And what the beautiful thing is about the appellate courts, whether it's at the state level, you have the trial court, you have the intermediary appellate courts, and then you have a Supreme Court in the states as well as obviously in the United States. And if you think about it, some of the most significant cases that have been decided, all right, some of the most significant cases have been by pro se defendants. who's kept on and said what they're doing is not right, and they appeal, and everybody thinks they're crazy, and everybody thinks, oh, they've got nothing to hang their hat on. Why is this person doing whatever they think they're doing? They're not going to win. And there's one person at a court, and they look at it and say, you know what? This guy has an issue. And then they appoint them an attorney. And that attorney says, you know what? This guy's got an issue. And the Supreme Court will reverse it and say, all of you people out there who thought that this person was wrong, you thought their argument was crazy, you were dismissive of those arguments, like I've had happen many times to me, and then you're vindicated. I remember once I had a case not too long ago. It was a co-defendant case. Evidence should not have come in because the eyewitness to it had passed away. And there's a case called Crawford v. Washington that Justice Scalia wrote, and it says you can't bring in hearsay statements of a dead person because it violates the Confrontation Clause, the greatest truth-seeking tool ever created, the Confrontation Clause, where it means somebody gets to get up there and cross-examine and question the testimony of the person up there. And the judge said, well, I'm going to allow it. I think there's sufficient safeguards. And I made my objections. Client gets convicted. Another jurisdiction actually dismissed similar charges because of the same set of circumstances and wouldn't allow it because they read the law. And this particular judge thought he was going to do the right thing and to do justice. Well, justice would have been dismissing the case. It goes to the Court of Appeals. They said, haven't you read this particular case? And they were rather frank to the judge, and they reversed him. And the judge dismissed everything off the record. And I literally was saying, no, I want to have a hearing. I want the court to say that the Court of Appeals had reversed everything that had taken place. So although I'm not right every time, and some people may think I'm not right a lot of the time, but usually I have a pretty good idea of how things are going to turn out. And so I hope the judge, this Judge Honorable Farron Z. Edens, made a good record so that his finding that there was a conflict in the Lori Vallow and Chad DeBell case, the waiver will hold up. And my experience is it will be the first thing that is attacked on anything that takes place. We'll see. Short of a acquittal, there would be an appeal. Mark my words. And so that's just, it's. We'll see. Let's go back to some more of your comments here. Let's see here. Jules Cornell, 2.3 million people as of 2016. 2.3 million people were incarcerated in the United States at a rate of 698 people per 100,000. Jules, I have no reason to dispute your numbers. I know there are a lot of people in custody in the United States. Now, let's also be realistic, okay? I'm not one of these criminal defense attorneys that believes that no one should ever go to prison. Sometimes people, you got to go to prison. I'm a general believer, and most district attorneys will get this. You got rape, murder, violent crime, and everything else. Obviously, those things, you can't have people running around doing violent crimes and getting away with it. There's some people that are dangers to the community. Some of the biggest dangers to the community that I've ever seen, white-collar criminals, stealing money, conning little old ladies. Literally, some of white-collar criminals are some of the most manipulative and dangerous people out there. They don't inflict the emotional or the physical scars on people, but the emotional scars can be tremendous. When somebody takes away something like that, or they take away little old ladies' funds and they get them to transfer all their money out of their accounts and things like that. It's It's horrendous. So there are people that need to go to prison. All right. There's some people out there that thinks no one should go to prison, but at a certain point when you commit violent crimes, there's just certain crimes. Listen, you have proven that you cannot function properly in society. And you got to, for that reason, there's a certain point, there are certain people that need to be locked up. I've said this before. I have seen pure evil. I have met pure evil, maybe a handful of times, but these are the type of individuals that literally make the hair on the back of your neck stand up when you're in a room with them. They're the kind of people that you have associate attorneys in there, and they're like, they're telling you, I can't be in the same room. I can't work on this guy's case. Just pure evil. Those people need to go away and be locked up where they can't harm anybody, or they stay away for the longest time that they're so old and decrepit that they need to stay away from society. Some people, let's face it, some people are just not wired right. And sometimes, yes, a lot of the people in the criminal justice system have mental health issues. And if we can treat those mental health issues for a heck of a lot less than it would take to lock somebody up at the cost on an average of $32,000 to $38,000 a year, well, that's just good common sense. That's good business sense. You got to save the space for the violent people. And don't get me wrong, they will. So we'll see. We'll see. Going back to a couple of the questions, Scott, in the meantime, your client was sent to prison. Yes. The question, Dan, Scott, in the meantime, your client was sent to prison until the court reversed the case. Yes, that's what's frustrating. Okay. Somehow people think that if you become a judge, you are somehow all knowing and you get everything right in the law. No, that's why we have appellate courts. And, you notice how you trial court, you got one judge. Appellate courts, usually it's a 3-judge panel, unless you go to, what they refer to the en banc, which is the entire bench. They're usually broken up into various levels. Say there's 12 judges, you get, 4 3-judge panels, and they got to rule 2-1, right? One way or the other. So the hope is that now you have to convince even more people that the error was made. And obviously, if you go to the Supreme Court, some have 7, some have 9, like we have in the United States Supreme Court. And so you have to convince more and more people that, an error was made. And if people say, hey, the mistake was made, then that's the whole point of it. And don't get me wrong, not every case that goes up on appeal has merit. Don't get me wrong, we've lost cases. We've had a lot of cases reversed in the trial courts. We've had a lot where they're like, oh yeah, nice argument there, Mr. Reich, but we're not buying it. You're wrong. Very creative, but you never know. I mean, like I said, that Crawford v. Washington case, people had been making that same argument that it's a violation of one's constitutional right not to have the victim present and be able to confront them. People have been making that argument for 20 years. And the courts were just dismissing it, denying it, poo-pooing it. One of the cases that the United States Supreme Court cited to when it came to Crawford was a case out of Colorado. And they said, you can't do this. And what the issue in Crawford was, it was over the course of time, the Constitution was there to make things difficult for the government because we're dealing with people's freedom, their liberty. We want it to be difficult for the government to take away somebody's liberty. So, for example, the biggest case where this came up was domestic violence cases. The victim in a domestic violence case doesn't want to testify, but she said all these terrible, bad things about the defendant, and it would convict him, obviously, or she, if they were allowed to testify. They don't want to testify, so they came in with all these exceptions. Well, there's a certain amount of reliability because it was made very shortly after the alleged incident, and therefore they didn't have time to fabricate it. Other opinions said, well, there were time that went by, and then so therefore we should put more reliability based upon the statement because they've had time to cool down, to reflect upon what took place. So therefore, there's reliability. And so really the court created a rule that helped the district attorney help their case whichever way it was. And finally, it was a court-appointed attorney, kept making the argument out of Washington State. The appellate courts looked at it and they said, this is not what the founders would say is appropriate. That's why your accuser has to come into court and point to the defendant, just like they do it in the TV movies all the time. Do you see the bad man that robbed you in this courtroom? And they point and said, he's right over there. They need to do that. Accomplishes two things. One, they have to prove identification, which we've talked about a lot on our program. But second of all, it satisfies the right to confrontation because after the district attorney asks those questions, the defense counsel can get up and say, well, let's talk about your statement. You said this, but you've told 4 other people that you were unsure about it. It was dark, wasn't it? You said there was a gun. Have you ever heard of gun focus and how that relates to faulty identifications? And so you get to cross-examine them and you let the jury decide. Convince 12 people beyond a reasonable doubt, ladies and gentlemen. So that's where we are in that. Let's go back to some of the questions here in our limited time that we have. Lisa, little question, speculation here. I wonder how many more of Chad and Lori's immediate family would mysteriously die if they were free and looking for more quick cash. Certainly don't know, but certainly I wouldn't want them spending the night at my house. People have a tendency to die mysteriously of things. Let's see here. Go on to a couple of questions. Cheryl, glowing embers. Try not to send my question. It's not connected. Can you ask him for me? Let's see here. Try to read these as hearsay. Okay. I'm not even going to try how to pronounce that. APHETRERRYAC. Hearsay are tricky rules. In the Peterson case, the prosecutor was adept in creating, presenting, and persuading a completely circumstantial evidence case. It's all about the presentation. Oftentimes, it is about the presentation. There are lots of exceptions to the hearsay rule. But a good attorney on their toes will be able to keep those statements out if, once again, they're not subject to cross-examination. And, data and records, those kinds of things can be authenticated as a business record. However, if they're created just in anticipation of litigation, that's not a business record. A business record, for example, phone records are things that are saved and created all the time, routinely, not just when you think litigation is going to be popping up. Let's see, TX Angel. I was robbed in my apartment by maintenance man. I complained. They filed eviction. I countersued. Judge would not allow me to mention the theft. It's all set up. Never late on rent. 3 years. Crazy. Yeah. I mean, there are a lot of circumstances, ladies and gentlemen. I'm not going to say that things always go fair in court. It's simply each case is different. But appeals, and the problem is appeals take time. Appeals are expensive. If you go to prison, you're going to appeal, but if you get evicted, you're going to appeal. It's tough to do that. In the meantime, then what happens if you don't have money? And I'm not saying you didn't have the money to pay your rent, but in that particular situation, but you got to post appeal bonds, you got to post transcript costs. Those kinds of things are expensive, and they could take months and months of time. All right, Mr. Scott, Glowing Ember keeps asking a question, sending you super chats. Let's see if did I miss something. Glowing Ember. Let me go back here. Let me go back. Okay, I see a Glowing Ember super chat, but I see no question there. There's no question. It's just blank. Glowing Ember. It shows a super chat, but no question there in the actual super chat. So trying not to miss anything. I just went all the way back up to the top and didn't see anything either. So sorry, Glowing Ember. Just go ahead and ask your question. I'll be looking at it here. Let's see, Susie. Susie, do you believe that there are more actors in the Daybell Vallow case besides Alex? Well, Susie, based upon the evidence that we've seen thus far, which obviously has been somewhat limited, but we do have the affidavit for arrest warrants in both cases, and it would appear that the people that were involved, allegedly, giving all the presumption of innocence, would be Chad, Lori, Alex. I think that may be it. There's nothing to indicate so far that anybody else was involved. You know, obviously, if you're going to engage in illegal conduct, the smartest thing would be to involve the least amount of people possible so that they cannot, roll against you, so to speak. Okay, Glowing Ember. Got it. Here we are. Curious as to your impression of Lori not showing up for the hearing. I'm wondering if she's making a statement to Chad that she doesn't want anything to do with him. Very, very interesting. Obviously, the hearing that was held on Monday at 2:30, which was in regards to the motion to reconsider that was filed by the district attorney saying, Judge, please do not allow live video streaming of the preliminary hearing because it could taint the proceedings and affect the defendant's right as well as the government's right to a fair jury trial. For those of you who watched that particular Zoom call, obviously Mr. Means was there. Mr. Pryor was at the jail with Chad Daybell, who was dressed out in a shirt, was not in jail garb. You had the district attorney and the judge. But very noticeable that Lori Vallow was not present. Now, who knows? She could have been sick. Maybe she just wasn't particularly interested in that. But you would think that if she wanted to see, the love of her life, her heartthrob, that would have been her moment to do that, to see his smiling face on the Zoom call. He wasn't there. It would be speculation to say that there's completely there could become something completely innocent. Maybe she just wasn't feeling well. Maybe she wasn't interested. Maybe she had an interesting class taking place in custody and she didn't want to miss it. So, we just have to wait and see if something comes of it. Jay Fletcher, Scott, did you say Tammy's death was of natural causes? Well, we don't really know yet. I was stating that, Chad must have obviously been what a lucky guy. He's engaging in extracurricular activities with Lori Vallow. And, literally 2 weeks before he wants to run off and get married, she mysteriously dies, of what they originally determined would be natural causes, because as we all know, no autopsy was performed at that time. Now, let's face it, if your wife who runs, I think she was training for marathons, things of that nature, mysteriously dies one day, I would think I'd want to know what the hell happened. How did this happen? Not, oh my gosh, I'm so distraught and heartbroken. Let me go marry this woman, Lori Vallow, 2 weeks later. I mean, come on. It's just, maybe it is, but, we haven't seen that type of information. So I'm not saying necessarily natural causes because we don't really know yet. We're just going to have to wait and see. Let's see here. Maybe D.A. Grace. Maybe she didn't have any lipstick. That's true. Maybe is, her, we've noticed last time, and I get in trouble if I say, maybe her appearance for court, maybe she wasn't going because it was kind of last minute. Who knows? Who knows for sure? Manuela Costalima, since Chad is looking more like Elmer Fudd than God these days, Lori is slowly getting very cold feet. Couldn't be enough to match her frozen heart. Ladies and gentlemen, it's a great quote. I read it in a case once, and I literally copied it, photocopied at one point. I think I still have it somewhere in a file of interesting quotes, but it says, the threat of imminent incarceration tends to break the bonds of loyalty. And that would be one quote that I would have told the judge when he was deciding the whole Lori Vallow, Chad Daybell issue of whether there was in fact a conflict. Judge Edens, the threat of imminent incarceration tends to break the bonds of loyalty. That is in and of itself, even if you think there was a waivable conflict, as to why there can't be. And the question then is going to become, if there is that conflict, are they going to use it against each other? Did they learn that through their communications during the representation of the co-defendant? And if somebody rolls, it's going to be an issue. That's absolutely the way it is. Yes, Anna Maria, the autopsy on Tammy was not done. It is not the case. They are mandatory. Why not in Idaho? Like I said, small towns, people die, but, she was relatively young. It's my understanding she was in good shape. I saw photos where she was apparently out training. So, it's just odd to me that somebody didn't do that and didn't get even more suspicious when, like I said, they bury her within 2 weeks. He's off to Hawaii getting married. Like, does that not make somebody think, wow, maybe it was completely innocent. Maybe it was just complete luck. Maybe all the stars and planets aligned. Maybe the portals were opening up and just figured this is it. Danielle, thank you. Thanks for watching. Listen, if there's one thing one could say about Lori Vallow is that you can see from all of her interactions that she's had, she could be characterized as a survivor. All right. Bad situation. She gets up, she moves along. Lori Vallow, in my humble opinion, would dump Chad Daybell in a heartbeat if a better circumstance or situation came along. And that better circumstance could be, by God, if somebody should go to prison, let it be Chad. She would roll on him in a heartbeat. Because now she's going to simply claim, oh, I had no idea. Who knew what those two were up to? Clearly, Chad and Alex were communicating. They're the ones that all the text messages appear to be going back and forth to. We've seen nothing as it relates to her cell phone, kind of cutting her out of the picture. Interesting how that works, isn't it? Just my humble opinion once again. All right. So a couple things. So after we get done here, we've gone just about an hour. We're a little shy of an hour at this point. But after we do that, we'll be going to our Patreon page for our Crime Talk Patreon members. And once again, we'll be taking questions. But in that particular format, we also have the ability to take phone calls. People can call in, we queue them up, we answer the questions. We'll stay as long as people have questions and we can talk. So anyone who's interested in that, go to our Patreon page, sign up. Please do so. You don't have to, but it's an option where, like I said, we can have one-on-one time and we will actually do the phone calls and we'll talk about it. More interactive, obviously, than trying to answer questions here along the way. Now, I know some people don't like it, but we have advertisers, we have sponsors, and they like for us to tell the world about their product. And we've received lots of positive feedback as it relates to the background check subscription that's available. If you go to CrimeTalkSearch.com, sign up for this. You can do background searches, ladies and gentlemen, anonymously. You get a report immediately. What is in somebody's past phone numbers, emails. You see your husband's strange email or phone numbers. Guess what? You type those in, you get the information. It's rather amazing. We use it in our law firm all the time. We've had more people say, Scott, thank you for turning me on to this. I used it. I was going to get into a business relationship with somebody, and it turned out they had theft and fraud type of crimes in their past. Other people found out that their potential boyfriend may have been charged with doing terrible things to children. Those are the type of things that you need to discover in any kind of relationship you're in. So go to CrimeTalkSearch.com and sign up for that today. Please, you'll be happy you did. Kathy, we hope you make it to our Patreon tonight. When we get done here, we will do it rather quickly. Obviously, I think the big issue we want to talk about is, in greater detail, is the opinion by Judge Edens. I shouldn't say opinion. It's more of just an order where he apparently had a sealed hearing regarding the potential conflict of interest that takes place between Mark Means and his now existing client, and apparently his past former client, Chad DeBell. And after listening to arguments as well as reviewing documents submitted by the court found that there was a conflict and that it has been adequately waived for the current proceedings, which is interesting because, does that mean just for the preliminary hearing? This case alone, can it change down the road? I, as just your everyday, lovable, everyday criminal defense attorney, thinks there was a conflict. I think there was a conflict early on, and I think the judge should have said conflict once and forever and for always. That's just the way it is. We have a similar situation right now in our law firm. I can't go into great details, but it's regarding a client that we have, and the other attorney on the other side had represented him, and he wants to be a part of it. Like, you can't. So it's just something that once there's a conflict, there's a conflict. And I don't think you can waive 99.9% of them. And it's just bad precedent. It's bad law, and it creates more issues down the road. So I want to thank everybody for tuning in for our live. Make sure you watch the video that we put up this evening, and go back and watch all our videos. Please do. Gwen, I'm sorry I cannot marry you. I'm sorry. The lovely Miss Kristen would be very, very upset with me. Jenny, Una of a Kind Art, thank you. I appreciate that you think that I am so lovable. That's right. I'm your everyday lovable defense attorney. So we want to thank everybody. Nancy, judge who was over the live stream or the trial are different. Yes, they will be. One's a county court judge. And, who knows? This issue could be raised again at the district court level, not the misdemeanor where it's starting out as of right now. Jessica, sign up. It's worth every penny. I'm telling you, go. People you've made come in contact with, people you're going to get, I'm telling you, sign up. It's the best thing you do. What do we do? Just about every case, we run a criminal history on key potential witnesses, and we work from there. You just never know what you're going to find. Sometimes it's nothing, and you're completely satisfied. Other times you find stuff you wouldn't believe. We had a case not long ago. Credibility's a huge issue. It was a case we took over. Guess what? We found the guy had all these judgments against him for what? Fraud, crime of moral turpitude. Guess what? Goes directly to them. Told opposing counsel what we found. Guess what? It completely changed their mind. It's invaluable. Information is power, ladies and gentlemen. And to do that, you need to get that subscription. Thank you so much. And that's a great idea. We'll see. We need a teddy bear in our store. That would be great. We have a little teddy bear with Crime Talk shirts. Says, let's talk about it. I agree. We'll see if we can make that happen. If you need your Crime Talk merchandise, go to the link below, buy it. They'll ship it out to you right away. Thanks for watching. We're going to end now, and we'll be on our Patreon page in probably 15 minutes. We'll see you there. Go to Patreon and join us, and we can call in. Have a good night.